Hello everybody, I am Anu Priya and I am representing Rai University. I am assistant professor over here. Let's start with the third lecture series of Transfer of Property Act 1882. So here in this lecture series we will start with section 8 of Transfer of Property Act. In the previous lectures we have already covered till section 7 of Transfer of Property Act. When we read the Transfer of Property Act from the Bare Act, it basically reads with operation of transfer, which basically means the effect of transfer. What are the basic effects of transfer of property? So if a property is already transferred, what will other things will transfer with the property? So in general, the sections actually says unless a different intention is expressed or necessarily implied. From the first line, you can understand it is actually talking about the contract to the contrary basically. So if the parties already have the contract in between, then that will be the different matter. But otherwise, what are the general rules for that? So here you can see a transfer of property passes forthwith to the transferee all the interest which the transferor is then capable of passing in the property. So whatever rights, whatever interest belongs to the transferor will be passed to the transferee. So with the property, whatever rights and liabilities, and it's not about liability but basically about the rights and interest which belongs to the transferor with the property will pass to the transferee. So the new rights will create to the transferee and the end of the rights and interest in the behalf of the transferor will basically happen with the effect of transfer. So the next line what is said about and in a legal incident thereof, such incident include where the property is land, the easement annexed thereto, the rent and the profit thereof occurring after the transfer, and all the things attached to the earth, and where the property is machinery attached to the earth, the movable parts thereof, and where the property is housed, the easement annexed thereto, the rent therefore occurring after the transfer, like rocks, keys, bars, doors, window, everything will be passed on. So here what the section is telling us about is basically when if a person A transfer his property. For example, if you transfer the land, in the previous lecture we understand what the easement are basically. You can refer it for understanding the easement. So over here let's talk about it in briefly. So if a person A transfer a land to the person B, so here the transfer is in between two living person. So if the property belongs to A, the rights over that the property, the ownership belongs to A. So this ownership is basically transferred to B as a person. Now the transferee have that land. So with the property, if there is an easementary right as well. For example, there are two plots adjacent to each other and the plot 1 and plot 2. If there is no way to reach the road, and the second plot basically granted a pathway to walk off and reach the road. So over here that pathway is basically the easementary right. So the easementary right will also pass on with the transfer of the land. Simple. And the next thing what is talking about is if you transfer a house, basically a house. So if you transfer the house, the everything which is attached to that house is like whatever immovable property basically is. For example, if there is a house, house is an immovable property. So everything attached to that house like doors, keys, locks, ceiling fan, everything which are attached for the permanent purpose basically with the intention of permanently fixed it up with the house, then that things will also consider as immovable property and that will also pass on to the B. So if the A transfer the property, that is house, to B, so everything which is attached to that immovable property will also pass on to B. Okay, so here what is said, the locks, keys, bar, doors, window, everything will pass on. Everything which is provided for the permanent use thereof, and where the property is a debt or other actionable claim. In the previous video we have already talked about the actionable claim. The securities therefore, except where they are also Other debts or claims not transfer. So the liabilities which are attached to the property, these are like actionable claim and debts. These are not the transferable things. And areas of the interest will also not transfer except the contract to the contrary. If there are condition imposed, if there are something else, if there are something contract in between them, then that will be a different thing, but basically these are not transferable. So next slide we talks about the oral transfer. So what are the process of transfer of the property? Whether it should be a written or whether it should be a oral. In general, what the Transfer of Property Act actually says, lays down that a transfer of property may be made without writing in every case in which a writing is not expressly required. So wherever writing is not expressly required, you can do the oral transfer. But this section 9, which talks about the oral transfer, is not complete in itself. So if you refer the Registration Act or if you refer the other sections of the Transfer of Property Act, like section 54 or the lease concept or the mortgage concept, there you can see that if the property is of the worth more than 100 rupees, you should have to make an instrument to pass on that property basically. So here in nowadays it is very understandable that the property is not possible that the property does not belong to more than 100 rupees. So here what the concept is, so if the property is more than 100 rupees, what you have to do, you have to make a registered instrument to pass it property. So basically you have to make a writing concept. What about the lease? In lease as well, if you make a lease of more than 12 months, then you have to register it with the instrument. So these are the things where you have to do the registration and you have to do it in writing basically. So if the property does not belong to less than 100 rupees or if the lease is of less than 12 months, these are the other provision you can consider to understand this concept in more better way. So the next heading is condition restraining alienation. This is actually the section which is I am referring over here is section 10 of Transfer of Property Act. What the bearers tell us about? Where the property is transferred subject to the condition or limitation. First of all, we have to understand what the term alienation is about. Restraining alienation. So we are putting condition over transfer. So if a person A is transferring a property to person B, he is also putting some condition over here. What condition he is actually putting over here is restraining alienation. What is restraining alienation? What alienation is about? Alienation is about extinguish, to end up something, to destroy something. So what is actually destroying? Is they destroying the property? No, not at all. The property is being transferred. What is actually end up over here is the rights over the property, the interest over the property. So whatever rights have A while he is actually having the ownership of the property is restrained and B's right is creating, but now he's putting the restriction over B that you don't have the power of alienation. Now the B will not transfer the property to any other person. So what kind of transfer it is? If a property belongs to B, ownership belongs to B, the possession belongs to B, he does not have right to transfer it to any other person. Let's suppose C, he cannot transfer it. These are the conditions that A is putting through. What the section is actually telling us about, that where the property is transferred subject to the condition or limitation, absolutely restraining the transfer, restraining the transferee or any person claiming under him from parting with or disposing his interest in the property. So it is about absolutely restraining. It's not about the partial restrainment. It's about absolutely restraining. A is absolutely restraining B to dispose of the property, to transfer the property, or not just transferee, not just B, any person claiming under him. Any person. Who are the any person? It may be the heirs of B, it may be the son, it may be the wife. So if A is transferring the property, so it is about that he cannot even restrain B but also not restrain the heirs of B or the other person who have the interest over the property basically, who have the interest of the property. The condition or limitation is void. if he is putting this condition, what the condition will be? The condition will be void. One thing you have to note over here is the condition or limitation is void, not the transfer is void. The transfer will remain valid. The property will transfer to B. The ownership in the property will belong to B. But what is not transferring? What is void? The condition of alienation which is putting by the A is void. The limitation is void, except in the case of lease. But the exception is what? Lease. Lease is the exception. Basically, what happened in the lease case is that in lease, the property ownership does not belong to the person whose lease is actually contracted. Not possible. What is there? Their transfer is ownership is actually transferred. Is possession is actually transfer, not ownership. Ownership does not transfer in the case of lease. So over here, what happened that the condition is for the benefit of lessor or those claiming under him. So over here, lease is the exception. There you can put the condition restraining to alienation, because in lease the ownership does not transfer. If the ownership does not transfer, the ownership will remain with the A. So B will not transfer the property to anyone else. Okay, one more thing over here is Mohammedan Buddhist. You can see that provided that property may be transferred to or for the benefit of women. So other restriction, other condition, other exception of this section is about women. Women. If the woman not belong to Hindu, Mohammedan or Buddhist. If the woman is Hindu, Mohammedan and Buddhist, then it will be governed by their personal laws. Over here, if the woman is not Hindu, Mohammedan or Buddhist, in that case, if the property is transferred to the woman for his maintenance, for her benefit basically. So if there, for example, if we take the example of Hindu widow, if Hindu widow are transferred a certain amount of property by the father-in-law, so for that purpose, that woman should be getting the maintenance over the time. So in that case, women cannot transfer the property. This condition will be valid. Next is section 11. Section 11 of Transfer of Property Act, basically what it deals with restriction repugnant to interest created. So in the section 10, we have read about the condition restraining to alienation. So over here, what are the conditions? Restriction repugnant to the interest created. What does repugnant means? Repugnant means contradictory, opposite basically. To interest created, whatever interest is created. To whom the interest is being created? The interest is being created on the part of B, on the part of transferee. So the new transaction, after the new transfer, new right and interest created on the behalf of B. So over here the restriction repugnant to interest created, whatever interest is created on the side of B, if there is condition which is actually repugnant to that particular interest, what will happen in that case? This is what section 11 basically deals with. Section 11 what talks about is where on in transfer of property and interest therein is created absolutely in the favor of any person, but the terms of the transfer directs that such interest shall be applied or enjoyed by him in a particular manner. He shall be entitled to receive and dispose of such interest as if there was no such direction. So this section, what it actually indicates and tries to convey us is that where a transfer of a property and interest therein is created. For example, let's suppose with example, A is a person, he sold a house, he transferred a house to B. That house, the B purchased that particular the particular premises for building a shop basically. So A transfer the property for shop and B purchased it for shop. The consensus, the transaction, the intention was similar. Consensus ad idem. This is similar from both the side. Okay. So what happened later on that A put condition that you cannot use that particular premises for shop. B purchased it for the intention of creating a shop and A transferred it because A knows that B wants to create a shop over there, and now A is putting the condition that you cannot open a shop over there. So what is it? It is basically repugnant to the interest created. Whatever interest is basically created, now it is repugnant to it. So what is happening? That where a transfer of property and interest there is created, interest is now created absolutely in the favor. The absolute interest is transferred to the B in the favor of any person, but the terms of the transfer directs that such interest shall be applied or enjoyed by him in a particular manner. Now he is putting the conditions that you can use it in a particular manner. You cannot use it for the purpose you wanted to. So what is that? He shall be entitled to receive and dispose of such interest as if there was no such direction. So now what is happening basically is the condition what is putting, what is repugnant to the interest, that condition will become void. He will deal it as there were no such direction. Like there was no such direction was granted. Where now this is the exception part, where any such direction has been made in respect of one piece of immovable property for the purpose of securing the beneficial enjoyment of the another piece of such property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce such direction, or any remedy which he may have in respect of breach thereof. So what does the exception basically deals with? So over here, what the Transfer of Property Act drafting by Ripon sir is actually conveying us is that if let me understand make this concept clear by example. For example, A is a person. He is transferring a property, and the property is attached with a garden. So now the garden is being transferred to the person B. Okay, the property attached with the garden is transferred to the B, and that property which is attached to the garden is actually a farm. A is using that particular property as a farm, so he transferred that garden to some other person, and now he put the condition that you cannot make a house which is more than 4 floors, because the sun rays will not reach my field and my field will not flourish overall. So he transferred the property to B. So over here, for the beneficial enjoyment of the farm, it is important that the garden should not be built with the building for more than 4th floor. So this restriction is valid restriction. This is what the exception of this particular section is. So next we move to the section 12 of Transfer of Property Act. Transfer of Property Act section 12 deals with condition making interest determinable on insolvency or attempted alienation. This section is also dealing with another kind of condition. So what this condition is basically talks about, this condition is about making determinable an insolvency or attempted alienation. So over here we are also talking about alienation, attempted alienation. Now what happened over here, the B, the transferee who wanted to transfer the property to someone else. So he wanted to, he is making the step to. So what this condition is about, you cannot even make the attempt. You cannot attempt to transfer this property to someone else. And what else it is? Interest determinable on insolvency. If the person B becomes insolvent later on, if he declares himself insolvent by the order of the court. So what will happen, that if he become insolvent, then he cannot attempt to alienate. If this kind of condition was there, then this section is dealing with that particular condition. So what this section is about, where the property is transferred subject to the condition or limitation making any interest therein reserved or given to or for the benefit of any person to seize on his becoming insolvent or endeavoring to transfer or dispose of the same, such condition or limitation is void. So what this condition and limitation will become? This condition and limitation will become void at all. So the transfer is valid, but the condition will be void, that the person B have the right to transfer it even he become insolvent. This is what this section deals with. Okay, but there is exception part. Nothing in section applies to the condition in the lease for the benefit of the lessor or those claiming under him. So basically the concept is same as per the section 11 as well. What happened over here? In the case of lease, this is the exception. In case of lease, you can make the condition like this. You cannot transfer the property even if it become insolvent, because the property does not belongs to you. Then how can you transfer the property? You only have the possession in the case of lease. Now section 30. What the section 13 is dealing with? Section 30 basically deals about transfer for the benefit of unborn person. So the transfer of the for the benefit of unborn person. What we have earlier read in section 5 is that the transaction can only happen between two living person. And the unborn person is a person who is not in existence yet. He is not yet born, not even in the womb of the mother. So then he is not at existence. He is just about the presumption and assumption. So if anyone wants to make transfer to unborn person, there is certain provisions in these transfer of property act that how you can do this, how this will be happen. So here what this section is actually talking about, where on a transfer of property an interest there is created for the benefit of a person not in existence. So if a person is not in existence right now, he is unborn, at the date of the transfer, when the transaction is actually happening, the transferor conveys the property to the transferee. In that case, if the person is not in existence on whose behalf he wanted to transfer the property, then what he have to do, that he have to create a benefit of such person shall not take effect unless it extend to the whole of the remaining interest to the transferor in the property. What basically have to do is that he have to create a life interest to some living person. That A is a person, he will transfer the property to B. B is living at that time, he will create the life interest over that property on B. So after B, the property will transfer to unborn person. If the unborn person will get birth even in the lifetime of the that person living, lifetime of the person B, then the property will transfer to unborn person automatically. But that transaction will be complete, will be the interest created for the benefit of such person shall not take effect unless it extend to whole of the remaining interest. That you cannot say that after X, that after that unborn person, it will transfer to another unborn person. This cannot happen. This will not allowed. So what is actually happening? You can transfer the property to unborn person by creating a life interest to another person who is living at that time, but that interest should be absolute. Now the X, whatever that unborn child will be, the whole right, the whole interest will be created on the behalf of that unborn child, that he has right to transfer it, right to alienate it, right to sell it, whatever right it is, it will be complete right over that unborn person. Okay, the illustration is actually talking the same thing, but I actually have already dealt, that A transfer the property to which he owns to B in a trust and for A and his intended wife successively for their lives, and after the death of the survivor of the eldest son of the intended marriage for the life, and after his death for A second son. The interest so created for the benefit of the elder son does not take effect because it does not extend the whole of A's remaining interest in the property. So what is actually happening, that A is the son, second son, on whose behalf the property is actually transferring, is that it is not complete, it is not absolute transfer. So what is actually happening, this transaction will not take effect. So the next section actually is section 14 of Transfer of Property Act, which is dealing with rule against perpetuity. It is similar to what we have already read in section 13. So before reading this section, you have to understand the concept that what the government wants. The government wants the flow of the property. The property should not remain to one person. This is what the intention is. If the property will flow from one person to another, it will affect in the economy of the country. So this is what the basic idea behind every section is. So what perpetuity is actually about? Perpetuity is actually about, if you read the section, no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more person living at the date of such transfer, and the minority of the some person who shall be inexistent at the expiration of that period. That you cannot do that this property is belongs to me, like this property belongs to A. Now he wants to transfer the property. He will say that now this property will transfer to B, and after B this will transfer to his son. Then after that his son, the property will transfer to his son, his grandson, his great grandson. This is what? This is kind of perpetuity. The line of perpetuity. The property will move from son to his son to son to his son. So you cannot do this, because if you do this, the absolute right is not actually transferring to unborn person, right? So it is actually cancelled out by the previous section 13. You cannot do that. So over here it is also talking about that you cannot make a perpetuity of the property. The property should move. The property should move from one person to another person. So this is what the rule against perpetuity is about. You cannot transfer, you cannot say that the property will belongs to B, then it will move to C, then it will move to D, then it moves to E. This is not possible. If you are giving some rights to some person, then you have to transfer it absolutely. That if it will belongs to B, then after the lifetime of B it will belongs to C, and but then after, the C will have the complete right over that property, and C can dispose of, C can transfer or convey or alienate the property as per his will. This is what the section is actually dealing about. So this is over till yet section 14, and after that in the next series we will talk about section 15 onwards. Okay, thank you so much. Thank you.